Good morning. Please be seated. Welcome to today's administrative meeting of the Public Service Commission. Three of our commissioners are on business this week, including Commissioner Herman, Commissioner Linton, and Commissioner O'Donnell. We have joining the commission today Chief Judge McLean. Before we get started, we have minutes to approve from the meeting on September 18th, 2019. If there are no questions, is there a motion?
Mr. Chairman, I move that we adopt the minutes from the September 18th administrative meeting.
All in favor? The minutes are approved. Mr. Secretary, the consent agenda.
Mr. Chairman, we have 16 items on the consent agenda this morning. Item number 1 is Untitled Cloud Services, Inc. filed a request to cancel its operating authority and withdraw its tariff. Item 2, Masscom LLC and Telefiber Networks LLC, Broadview Networks, Inc. and Cavalier Telephone Mid-Atlantic filed a tariff withdrawal notice for Windstream Companies in accordance with Order 88353. Item 3, Talk America LLC filed its tariff withdrawal notice for PSC Maryland Tariff Number 10. Items 4 and 5 are filings from Sunwave USA Holdings, Inc. and Worthington Energy Consultants, LLC. They're both applications for a license to supply electricity or electric generation services in Maryland. Item 6 is NRG Retail Associates, Reliant Energy Northeast, LLC, Energy Plus Holdings, LLC, Energy Plus Natural Gas, LLC, Green Mountain Energy Company, Zoom Energy Maryland, LLC, filed its license updates in accordance with COMAR 205103 and 205403. Items 7 through 13 are filings from eNow LP, Southern Maryland Electric Cooperative, Inc., Columbia Gas of Maryland, Inc., Baltimore Gas and Electric Company, Chesapeake Utilities Corporation, Chesapeake Utilities Corporation for Sandpiper Energy, and then Elkton Gas. They're all its designated weather stations pursuant to 2031-0305 of COMAR. Item 14 is Esai LLC filed an application for commission approval to construct a generating station at the Greater Baltimore Medical Center in Towson, Maryland. Item 15 is the Maryland Department of Environment filed its response to a Maryland Solar 2 LLC social and economic assessment of the Ripley Road Solar Project. It's case number 9463. And finally, item 16 is the Maryland Department of the Environment also filed a denial of the joint federal-state application for the alteration of any floodplain, waterway, tidal, or non-tidal wetland in Maryland submitted by Maryland Solar, MD Solar 1 LLC, which is a Sugar Valley Solar Project in case number 9464.
Thank you, Mr. Secretary. Do the commissioners have questions on any of the consent agenda items?
Yes, Mr. Chairman. For item number 15, I had just a couple of questions just about, process and what we should do.
Do we have representatives from the Department of the Environment or MD Solar 2? If you could approach one of the vacant podiums. And if you could please make an appearance.
Sure. Good morning. Michael Padone, Assistant Secretary, MDE.
Thank you. Is there a representative from MD Solar 2 present? No. Okay. Commissioner Richard.
Yes, I just wanted to find out, have we heard from the company on this item? Have they attempted at all to respond to MDE, and have they expressed any intent to try to meet Condition 13 within the, the time period they need to meet it?
We've had no formal or substantive response from them. There have been some inquiries from some of their counsel about process, but no substantive response since we issued the letters on August 28th.
Okay, and it's my understanding from your filing, MD's filing, that you have been working with the company and trying to, advise them on how to meet Condition 13?
Yes, very much so. I mean, going back to the original filing of the application, the staff of our Wetlands and Waterways Program and our Water Standards Division have repeatedly met with the applicants to help them understand their the requirements of Maryland law and regulation, as well as process aspects of how we document things, what needs to be included in the application, numerous occasions.
Okay, and just from those contacts, I mean, is this an issue? And since the company's not here, if this is just speculation on your part, then no reason to answer, but is there a financial reason, or is it very costly for the company to meet this condition, or is it just a matter of understanding and I guess coming up with a response?
You're correct that it would require me to speculate, although I would say that considering other similar projects, we have seen other applicants able to submit the type and amount of documentation that we're requiring here without concerns being raised about it being an undue burden.
Okay. All right. Well, obviously, we take MD's concerns very, very seriously, but also, since we have this mandate in the state to increase our amount of solar generation, it also weighs on us to try to figure out how we make these projects successful. But just for my understanding, if we issue a finding today, does that lock us into a decision, or I mean, would it be better for us to defer this item until we hear from the company, or if you could just, you know,
Well,
advise-
it is striking that we have not heard from the company.
Okay.
I mean, one would think that there would have been some response as, you know, there's something we can work out, or this is something that cannot be worked out. Again, it's speculation why they're not here. It's kind of disappointing, frankly, but
Yeah.
it has been a notable silence from them.
Counselor, can I ask you a question? Since Secretary Grumble sent the letter notifying MD Solar 2 back on August 28th, you've had communications with the company, the developer, since August 28th?
Their counsel reached out to us informally, I would say about a week and a half ago, suggesting that they might want to come in and have a conversation about something. We indicated that we would want that to be a more substantive conversation, where they would hopefully provide some detail about what they wanted to talk about. So no meeting has occurred.
Okay, but they are aware that the decision has been made by MD. It's not a matter of this letter never made it to them or it was lost in the mail. They are on notice.
I have complete confidence that they are on notice.
Okay, in that case, I'm comfortable with making a finding today. Mr. Albert, do you have anything?
Well, just, yeah, we would think that they, you know, an opportunity to cure this defect would be something that, you know, if they've seen this report for over a month.
Right.
It's striking that they did not come back with some sort of remedial plan working with MDE. But again, I can only speculate that they don't view that as a reasonable, feasible alternative for them.
Okay. And if we do this finding or issue this finding today, that doesn't preclude them, does it, from addressing the condition 13
I
and,
would
and
think
returning
not.
to us?
Yeah, I would think
As
they
long
would.
as they do it before, I guess, next the date that's provided here, September 21st, 2021.
Right,
So
there
they
are
have-
other
they have-
deadlines coming up. We talk about the construction deadline, but yes, they would have opportunity to cure.
Okay.
Mr. Albert, MDE's permit denial of MD Solar 1 effectively would suspend the CPCN, is that right?
That is, let me,
Yeah, that's with respect to item number 16. And we have Mr. Wilson behind you.
That was mine, Your Honor. Yes, that's the case. Peter Wilson for staff.
Okay.
But again, they have ample opportunity to come in and cure and go through the process again in an attempt to get the permit. They're not prevented from doing that.
Okay.
Thank you, Mr. Wilson. And I suspect counsel for MD Solar 1 is not present either. I suspect they're the same. Okay. Thank you. Any additional questions? None. Chief Judge, can you provide the motions?
Yes, sir. For item number 1, I move that we cancel the company's operating authority and its related tariffs. For items 2 and 3, I move that we grant the company's permission to de-tariff with an effective date of October 2nd, 2019. For item number 4, I move that we grant the company a license to operate as an electricity supplier in Maryland for the customer classes and service territories applied for and recommended by staff, and direct the company to file notice with the commission within 30 days of any changes to the information in the application. For item number 5, I move that we grant the company a license to operate as an electricity supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff. Direct the company to provide marketing and training materials specific to its Maryland operations to the commission staff 30 days prior to utilization of the materials in Maryland, and direct the company to file notice with the commission within 30 days of any changes to the information in the application. For item 6, I move that we note the filing. For item 7, I I move that we approve the cancellation request for items 8 through 13. I move that we approve the weather station designations for the purpose of determining when there is an extreme weather period that requires restrictions on electricity service terminations under COMAR 20.30.03.03 and .04. For item 14, I move that we approve the construction of the requested generator and that the Commission finds that it meets the requirements for the exemption from the CPCN requirement as set forth in Section 7-207.1A of the Public Utilities article, and direct the applicant to notify the Commission in writing 2 weeks before the first export of electricity. For item 15, I recommend that I move that we note MDE's filing and find that MD Solar 2 has not satisfied PPRP condition 13, the Tier 2 stream protection condition of the CPCN issued by the Commission in case number 9463. And for item 16, I move that we note MDE's denial of the Wetlands and Waterways permit for MD Solar 1 to alter any floodplain, waterway, tidal, or non-tidal wetland in Maryland.
Thank you. All in favor?
Aye.
Any opposed? The motions are approved. Mr. Secretary, the administrative agenda.
Mr. Chairman, first item number 17, Baltimore Gas and Electric Company filed supplement number 635 to PSC Maryland E6 of the cost true-up of the administrative charges and transmission rates under Rider 1 of its standard offer service.
Thank you. Do we have counsel for BG? Thank you, Mr. Baker.
Hello, Chairman and Commissioners. Benjamin Baker on behalf of staff. BG filed revised tariff sheets to update Rider 1 administrative charge and to include transmission costs related to a FERC-approved PJM settlement that was previously not placed into transmission rates. When BG previously updated the transmission rates to include the FERC-approved PJM settlement, staff and BG disagreed if there was cross-subsidization, and the Commission directed both parties to determine if cross-subsidization was occurring. Staff and BG are still working towards a resolution. Staff supports approving transmission rates, but requests the Commission require the company and staff to finalize a solution before the next Rider 1 filing. Therefore, staff recommends the Commission approve the proposed change in tariff with an effective date of October 1st, 2019, and direct BG to finalize with staff the cross-subsidization issue by BG's next Rider 1 filing and propose a remedy if necessary.
Thank you. Does counsel for BG concur with staff's recommendation?
Actually, Your Honor, I believe that one of my clients and Mr. Baker had agreed that it would be not our next Rider 1 filing, because our next Rider 1 filing actually only impacts Type 2 customers, and so it would be the next Rider 1 filing so that it would be all customers. I believe that they had agreed to that small change.
Okay.
And that's by December, right?
Yes.
Yes, that's okay.
Okay, so it's not the immediate next rider, but the one after.
Right.
Okay.
Should we call it the December rider? What should we refer to that?
The next residential Rider 1 update.
Yeah.
Okay. Thank you. Do the commissioners have any questions? Thank you. Is there a motion?
Yes, Mr. Chairman. For item number 17, I move we accept the tariff revisions for the filing with an effective date of October 1st, 2019, and direct the company to finalize with staff the cross-subsidization issue by BGE's next residential rider update filing and propose a remedy if necessary.
All in favor? The motion is approved.
Next item, Mr. Chairman, item 18 is Armstrong Telephone Company filed revised tariff pages. The company proposes to make changes to its Maryland PSC tariff number 4.
Good morning, Mr. Chairman and Commissioners. Wanted to offer staff. Armstrong Telephone Company is one of 2 ILECs in Maryland. ILECs are telephone companies that have carrier of last resort obligations in their service territory. And Armstrong's service territory includes the town of Rising Sun near the Pennsylvania border and its surrounding areas. With this filing, Armstrong is asking that the Commission allow it to increase basic telephone rates for residential and business customers by $2.50 a month. Rates for basic local telephone service are comprised exclusively of a fixed monthly rate. On September 30th, 2019, OPC filed comments on this matter. Traditionally, for changes to basic local rates, the Commission has required that telephone companies regulated under rate of return regulations, such as Armstrong, undergo a full base rate case in order to determine just and reasonable rates to end users. However, in this instance, Armstrong is requesting that the rate increase be approved outside of the rate case process. Staff agrees for the following reasons. First, this is a revenue neutral change and is meant to make the company whole for the revenue Armstrong forgoes due to a reduction in originating switch taxes, which became effective July 1st, 2019. The reduction to switch taxes rates has been endorsed by staff in the past and is the subject of a rulemaking request currently before the Commission. Staff has reviewed the company's calculations and is confident that the rate increase is in fact revenue neutral. Two, the rate increase is just and reasonable. Armstrong's rates are well below the industry average. As described in staff's write-up, Armstrong has not had a rate increase in 36 years. Armstrong's proposed $8.50 rate for residential customers is significantly lower than the $22.63 rate paid by similarly situated Verizon customers immediately outside Armstrong's service territory. These rates are also significantly lower than the rates paid by Armstrong customers in Pennsylvania. Three, a full base rate case might be prohibitively expensive for Armstrong and might have some unforeseen consequences. There's no recent history of base rate cases for telephone companies in Maryland. However, similarly sized water companies have filed rate cases in the recent past. A quick review of those cases by staff shows the rate case expenses for those companies can be as high as $500,000. Such an amount would represent a large proportion of Armstrong's annual revenues. If, as requested by OPC in their letter, the rate case includes a cost service study in order to determine allocations, those rate cases expenses could easily double. Armstrong is reluctant to burden ratepayers with such high costs, since rate case expenses are usually paid by ratepayers. Additionally, unlike water companies, Armstrong faces competitive pressures from cell phones and cable companies. As a result, any rate increase might mean that they lose customers, and the higher the rate increase, the more likely that will happen. Fourth, Armstrong's filing complies with all statutory and COMA requirements as described in the staff's comments. On a final note, ensuring that Armstrong remains a financially healthy utility while charging customers just and reasonable rates is one of staff's highest priorities right now. As a result, staff has requested that, should the Commission approve this rate increase, that Armstrong immediately initiate discussions with staff and OPC if they so desire on whether Armstrong should have a full base rate case, an A4 case, or some sort of intermediate solution such as a staff-assisted rate case. Armstrong has agreed to do so.
Thank you, Director Alvarado. Counsel for Armstrong.
Thank you, Commissioners. My name is Paul Hudson. I'm outside counsel for Armstrong. I'm joined here by Sean Bakai from the company. We appreciate the opportunity to appear today. We're primarily here if you have any questions. We do support staff's request. And I think principally we just want to reiterate that we have only 3,600 customers in Maryland. To conduct a full-blown rate case, which would be unique amongst all of the more than 200 telephone companies operating in Maryland, would be cost prohibitive for us. We, unlike other companies that may have a fixed captive customers, our customers can switch to Verizon Wireless, they can switch to other cell phone operators, other competitive over-the-top providers, and we do not want to push that increase on our customers. So we're looking for a practical solution. I think A4 is, of the ones listed, probably the one that makes the most sense, because I think a rate case in any form doesn't make sense in 2019, certainly for a company this size.
Thank you, Mr. Hudson. Counsel for Office of People's Counsel. And if you could just stay close, maybe right where you are, just in case we have some response needed. Ms. Ryan.
Good morning. Anna Ryan for the Office of People's Counsel. This is simply put as an issue of single issue rate making. As staff noted, Armstrong hasn't had a rate case in 36 years. In order to do single issue rate making, it would require the Commission to overlook its tradition of not doing single issue rate making unless there are extraordinary circumstances. In the time since 1983, when Armstrong had its last case, as you can imagine, the telecommunications industry has changed drastically, both in terms of technology and in terms of the regulatory regime at both the state and federal level. In that amount of time, Armstrong has not updated its rates to customers to adapt to those changing circumstances. OPC is concerned about keeping customer rates reasonable. And obviously, we don't want to require Armstrong's customers to pay any unnecessary expenses. However, Armstrong's customers should be paying enough for Armstrong to continue to provide reasonable service in their territory. And given the information that Armstrong has provided, there is an indication that Armstrong's finances are not in a position to allow them to continue to provide reasonable service. And we need to ensure that Armstrong's customers are able to continue to receive the service that they deserve to have, particularly with that carrier of last resort obligation. Armstrong's infrastructure needs to be maintained, and we need to ensure that their revenue is sufficient to provide that. As an additional concern, as part of Armstrong's failure to raise its rates, that has also cost Armstrong the opportunity to receive funds from the Universal Service Fund's Connect America Fund. In the FCC's 2011 Global Transformation Order, the FCC required rural carriers to raise their rates to the equivalent of the average urban rates in order to receive high-cost support for infrastructure. Armstrong has not been able to receive that funding because they have not raised their rates to the necessary level. Additionally, the FCC just last month took comments for the consideration of a Rural Digital Opportunity Fund, which again, without doing a rate case to ensure that Armstrong's customers are paying fair rates, Armstrong will not be able to receive those funds that can help provide reliable service and quality service to customers in its territory. So although OPC is not overjoyed at the concept of raising rates, there are a lot more issues that need to be considered. There are a lot of things that have changed since 1983, and we think that doing a single issue rate making in this particular instance is not an appropriate answer. We would be happy, however, to work with Armstrong and with staff to come up with a streamlined process for a rate-making proceeding. We understand it's a small utility, and given the length of time that has passed since the last rate case, the information available is going to be very different than what one would normally expect to see in a rate case. So we certainly would be supportive of engaging in a more streamlined rate-making proceeding in order to minimize the costs that need to be passed on to Armstrong's customers.
Thank you, Ms. Ryan. Ms. Ryan, what is the basis for your statement that Armstrong's not in a position to provide reliable service?
Armstrong has indicated that they're operating at a loss in Maryland. And at some point in time, if a company is operating at a loss, there is going to be a conflict between their finances and the network's needs. Whether it's happening now or not, it is certainly a concern about their ongoing ability to provide that service.
Can Mr. Hudson or the representative from Armstrong itself respond to that, whether or not there's any concerns with the level of service being provided now?
No, sir, there's not. There's no evidence, and certainly Sean and I are not aware of any service issues in Maryland. The company is small in Maryland, but it has substantial operations in other states, particularly Pennsylvania. It's well capitalized. It's privately owned, and I think we're fully committed to the customers in this state. One of the reasons that the rate hasn't increased and that there is a small operating loss is that it is so difficult for us in this pigeonhole that we're stuck in to adjust our rates in a way that might ordinarily be the case. But in terms of the participation in the funds, we do participate. We do get some funding from the Federal Universal Service Fund. There are other parts that we may not participate in fully, but all customers pay. The contribution rate now is 25% of every interstate telephone service bill pays into USF. I don't think it's necessarily a loss for us not to take funds that we don't need to have. I think that we're sufficiently operating in Maryland at this time, and there's no need to change that equation, I think.
Okay.
But it is should I address one other point, or would you like to?
You have the floor.
In terms of the single issue rate making, I do respect that there are bigger issues than Armstrong that have to be weighed by OPC and by the Commission in analyzing that issue. I would note, though, that the very case that OPC cited in its comments, the Commission did end up adjusting a rate because of an extraordinary circumstance in that case. And that is the case for us here. We have the tariff change that took effect already for us in July incurs approximately $100,000 of annual cost. When you're only charging $6 for the service, for 3,600 customers, that's a substantial portion of the revenue, and I think there is an extraordinary case to allow us to change this rate for the first time in 36 years to cover that cost before we wait to see what happens next.
Thank you, Mr. Hudson. Ms. Ryan, you're correct in that the Commission's precedent is one that we don't typically favor single issue rate making, but you would also recognize that we've done single issue rate making in the recent history with the Tax Cut and Jobs Act and some other devices where there was a pass through. Here in this case, you heard Director Alvarado that staff found that these rates are just and reasonable, well below the costs of Verizon and other carriers in the state. And with 3,600 customers, I suspect a rate case would cost those customers of Armstrong at least, let's say, $500,000. Did OPC take that into account, the cost of a rate case, whether it be streamlined or otherwise?
Certainly, and as I said, we don't want customers to pay unnecessary expenses, which is why we are willing to sit down and talk about what is the best way for Armstrong to get a rate adjustment based on all of its circumstances and not just this one issue.
Okay. Does the Commissioner or Chief Judge have any questions?
Ms. Ryan, so are you recommending throwing the increased customer charge into whatever streamlined procedure is created, hopefully?
Yes, we would consider this proposed rate change as part of the overall rate change that we would recommend.
And do you have any concerns with staff's finding that that the increase is reasonable?
I would say that we have been provided information from Armstrong that seems to support this. However, it would be nice to have a more thorough investigation into how this relates to other aspects of Armstrong's service and the opportunity to, cross-examine witnesses if necessary.
I just wanted to talk. You mentioned that you were concerned about the financial health of the company. I mean, is there concern by OPC that if we don't act quickly, that this change in tariff is going to immediately have an adverse financial impact on this company? So, I mean, you're proposing that have this discussion, which I think is important to have related to a streamlined rate case. But isn't there an urgency to this situation?
There is, and that's part of why we would urge that a rate case be done quickly.
But there first have to be a discussion about the streamlining of this rate case. So that hasn't happened yet. But in the meantime, there is an urgency, is there not, for the financial health of this company to serve its customers to address this one situation that occurs because of the change in the tariff?
I would suggest that urgency has existed for a number of years, given the financial information provided by Armstrong, and if they've been able to operate at a loss for a number of years, it would be more beneficial to conduct a full rate proceeding and include this in that rate proceeding and take the time necessary to do it.
Okay, thank you.
Based on the testimony of the parties and the arguments presented in the documents, I do concur with staff's recommendation, finding that the changes here would be revenue neutral, and I don't think any party here is arguing that it is not an unreasonable change in rate. For that reason, I'm going to support the tariff revision in the filing made by Armstrong. Commissioner Richard.
For the reasons you just mentioned, and I think it is an urgent situation, I will also support at this time the staff recommendation and also encourage to have these discussions about a streamlined process.
And Chief Judge McLean.
Just one quick question for staff. OPC had noted changing the tariff now is premature in light of the commission not having ruled yet on the regulations. Do you have a response to that, sir?
So yes, I do. Notwithstanding the fact that the regulations haven't changed, Armstrong's tariff did change. So their concerns about revenue are ongoing and have been ongoing since July. And that's outside of the rulemaking. The rulemaking was only meant to require everyone to go to that rate, but nothing right now precludes them from going to that rate, which I will say staff believes is the correct rate to have. So we believe that Armstrong has the correct rate, and because they have the correct rate, they're foregoing those revenues right now.
Thank you, sir.
Is there a motion?
Yes, Mr. Chairman, for item number 18, I move we accept the tariff provisions for filing and direct the company to file a clean copy of the revised tariff pages with an effective date of October 2nd, 2019.
All in favor?
Aye.
Any opposed? The motion is approved. Thank you.
Thank you.
Mr. Chairman, next item on the agenda is number 19. It's Fusion Connect LLC, CBON Communications LLC, aka Fusion Communications LLC, and Telecom Holdings LLC filed a joint application for a reorganization transaction, which will result in Telecom Holdings acquiring a controlling interest in the Fusion Maryland licenses.
Thank you. Do we have counsel for any of the merging parties with us? No, Mr. Albert.
Good morning, Mr. Chairman, Commissioners. This item addresses a filing that requests Commission authorization for Telecom Holdings, LLC, to acquire a controlling indirect interest in two Maryland telecommunications companies, Fusion LLC, I'll refer to as Fusion, and CBeyond Communications LLC, which is now known as Fusion Communications LLC. I'll refer to them as CBeyond. The transaction is associated with the filing by the Fusion companies, including Fusion and CBeyond, for bankruptcy protection under the United States Bankruptcy Code. Under Public Utilities Article 6101C3, Commission approval is needed for a public service company to acquire the capital stock of a public service company that operates in Maryland and is of the same class as the acquiring company. However, the entity that is acquiring the indirect parent of the two telecommunications here, that's Telecom Holdings, is not a public service company. That is, Telecom Holdings also does not have a controlling interest or otherwise control a public service company. Therefore, Telecom Holdings is not a public service company under the PUA, and therefore, as a result of that, authorization is not needed under Section 6101C3. Telecom Holdings LLC, is LLC, not a stock corporation, and for this reason, approval is not required under PUA 6-101C4. The applicants assert that the transaction will allow the Fusion companies to, one, emerge from bankruptcy protection as financially stronger, more competitive participants in the telecommunications industries, and two, provide their comprehensive suite of cloud-based and other communication services to their customers. Staff believes that Telecom Holdings' acquisition of Fusion and CBeyond is in the public interest. Therefore, staff recommends that the Commission note the acquisition by Telecom Holdings of Fusion and CBeyond.
Thank you, Mr. Albert. Seeing no questions, is there a motion?
Yes, Mr. Chairman, for item number 19, I move we note the acquisition of Fusion LLC and CBeyond Communications LLC, aka Fusion Communications LLC.
Thank you. All in favor?
Aye.
Any opposed? The motion is approved.
Next item, Mr. Chairman, item 20, Baltimore Gas and Electric Company filed a request for mandatory waiver of CPCN requirement for a project to rebuild an existing overhead transmission line.
Mr. Chairman, Commissioners, James Greger on behalf of staff. This item concerns a request from Baltimore Gas and Electric Company for a certificate of public convenience and necessity waiver pursuant to Public Utilities Article Section 7-207B4. PUA Section 7-207 requires an electric company to obtain a CPCN prior to commencing construction of an overhead transmission line that is designed to carry a voltage in excess of 69,000 volts. However, exceptions are outlined within the article. PUA Section 7-207B4I further states that the Commission shall waive the CPCN requirement should it find that construction 1 does not require the company to obtain new property or rights-of-way through eminent domain, or 2, require larger or higher structures to accommodate increased voltage or larger conductors. On August 1st, 2019, BGE filed a request to the Commission for a waiver from the requirement to obtain a CPCN. The request involves a portion of a 230 kV overhead transmission line located in Anne Arundel County, Maryland. The specific work, as outlined in the company's filing, includes the rebuild of the existing double circuit transmission line from tower number 1212 in the vicinity of the Lippens Corner substation to tower number 1256 in the vicinity of the NAJ substation. The company will replace 43 double circuit steel lattice towers, one for one, with weathering steel poles, replace an existing conductor, and 2 shield wires will also be renewed. BGE has identified the work associated with this project as necessary to maintain a safe and reliable electric system. This approximately 7-mile overhead transmission line has experienced substantial reliability problems, which have resulted in 29 fault operations over the last 10 years. This project will address installation aging, avian exposure, and reliability concerns associated with this segment of the overhead transmission system. In its filing, the company has stated that all work will be conducted in BGE's existing right-of-way and therefore will not require the company to obtain any new real property or additional rights-of-way through eminent domain. And while replacement structures will be installed, the conductor size will remain the same, and the existing 230 kV transmission line will remain energized at 230 kV. Based on staff's review of the filing and discovery responses from BGE, staff concludes that the completion of this project is necessary to maintain the reliability of the transmission system, and that the statutory requirements under PUA Section 7-207B4I for obtaining a waiver of the CPCN requirement have been satisfied. Staff recommends that the Commission grant a mandatory waiver of the CPCN requirement pursuant to PUA Section 7-207B4I, applicable for the work described in the company's filing. Thank you.
Thank you, Mr. Greger. I also understand OPC and PPRP do not object to the waiver as well. Counselor.
Good morning, Chairman and Commissioners. Jessica Reba on behalf of BGE. Thanks to staff for that summary. I don't have anything to add, but we're here to answer any questions.
Thank you. I note that the existing towers are 130 feet tall, but the new towers will be anywhere between 160 and 170.
So we actually got those numbers a little bit more precise. Those estimates were a little high, and the exact heights were provided in an attachment to staff DR 1-7, which I think was attached to staff's filing, which shows the exact height of each existing structure versus the new proposed structure.
Oh, the table. Okay.
Yes. So those original estimates were a little high.
On balance, however, the new structures will be taller than the existing structures.
Correct.
Okay. Does the Commissioner or the Chief Judge have any questions of the parties?
Yeah, we just asked one question. The staff write-up didn't really talk much about the outreach and notification. There was some discussion in the company filing. Was staff satisfied with the manner in which the company notified the public and impacted local jurisdictions?
Yes, Commissioner. We had no issues with it.
Very good. All right, thank you.
Okay, seeing no other parties wishing to speak on this matter, is there a motion?
Yes, Mr. Chairman, for item number 20, I move we grant a mandatory waiver of the CPCN requirements pursuant to Public Utility Act 7-207B4I, applicable for the work described in the company's filing.
Thank you. All in favor?
Aye.
Any opposed? The motion is approved.
Last item on the agenda, item 21, is Forefront Power LLC, FFP Maryland Snow Hill Project 1 LLC, filed a request for a waiver and extension of the operational deadline for community solar energy generating systems pursuant to COMR 2062-0304C.
Good morning, Your Honors. Annette Garofalo on behalf of Commission staff. Forefront Power LLC is seeking a waiver of the operational deadline established under COMR 2062-0304C as extended by earlier Commission waivers. This waiver would extend the deadline applicable to its FFP Maryland Snow Hill Project LLC, which is located in the Delmarva Power and Light Company service territory from September 30th, 2019 to November 4th, 2019. Absent a waiver, a project that fails to begin operating within 18 months of application must be removed from the electric company's pilot program queue. The only exceptions to this 18-month period under the regulations are failure of the utility to allow a completed project to operate or a pending legal challenge. Under Comar 20-6201-04, the Commission may waive a regulation in Subtitle 62 for good cause shown. As good cause for granting of this waiver, applicant cites the fact that at the end of July 2019, DPL informed Forefront that the Snow Hill project would not be able to be placed into commercial operations until certain required system upgrades necessary for interconnection were completed. DPL expects these upgrades to be completed in mid-December. For its part, Forefront will not be able to complete its Snow Hill project by its current commission deadline of September 30th, 2019. However, Forefront anticipates completion of the Snow Hill project prior to November 4th, 2019. The Snow Hill project is over 59% subscribed. In light of the problems involving interconnection and applicants' progress, including subscribing customers, staff recommends an extension of applicant's operation deadline to November 4th, 2019. Upon completion within this time frame, Snow Hill would be placed in the category of a completed project which the utility precludes from operating, and granted an automatic day-for-day extension by DPL under the regulations.
Thank you, Ms. Garofalo. Counsel for Forefront.
Hey, good morning, Chairman, Commissioner Richard, and Chief Judge McLean. Eric Wallace for Forefront Power. I'm joined with Brian Melashewski from the company here, and we appreciate staff's report there. And I think that staff summarized well the issues for this project and the reason we've come back for a further extension request. We're certainly happy to answer any questions about the details that the Commission has.
Thank you, Mr. Wallace. November 4th it's a Monday. It's a very specific date. Usually we see some of these requests round to the nearest month or end of the year. Is there any magic with respect to the 4th?
The reason we specified the 4th is because as explained in the filing, the project is structurally complete. So if you go out there today, you'll see what looks like a complete solar facility. The electricians are working on finalizing the electrical components of the system. And then before we can certify to the utility that the project is ready to operate and trigger that day-for-day extension of the regulations, we need to provide certain information to the utility, including a inspection certificate. In order to do that, we need to have house power from the utility to be able to test the systems at the project. And that should be done within that sort of local interconnection piece should be done within the next week. And that'll allow us to do the testing. It usually takes about 2 weeks. And then we need to prepare the materials to be provided over to the utility to trigger that day for day. So, so there's not really a lot of magic around the November 4th date, but that builds in that timeline to allow us to get the work that we need to get done and get all the information to the utility to make sure that we're able to trigger that day for day extension.
Thank you. Seeing no additional questions, is there a motion?
Mr. Chairman, for item number 21, I move we grant Forefront Power LLC a time-limited waiver of Comar 20-6234C2, extending the applicant's operational deadline to November 4th, 2019 for its FFP Maryland Snow Hill Project 1 LLC.
Thank you. All in favor?
Aye.
The motion is approved. Thank you. Have a great day. This meeting is adjourned.